but we also see who commissioned you on the 5th. Just explain why it is that that TM and that commission signature appear on this document.
It's simply because this document is the same document that we discussed earlier. The commissioner never signed anything further than he signed on the document submitted to this committee on the 25th.
Right. So is it your evidence that this is a copy of the 25th of February affidavit?
Yes, ma'am.
Let's go down to the next initials. At the top of the next page, 487, is it? Yes. Again, TM, that's you, correct?
Yes, ma'am.
And you signed there because you've made a handwritten change, correct? In that paragraph.
Yes, ma'am.
Right. Move on. Again, 7.3.
Yes, ma'am.
And again, the reasons are the same. You signed and you alone signed because
Yes.
of the change that's in 7.3.
That's correct, ma'am.
Explain again, Advocate Madonsela, and please be patient here. We really want to rule out any confusion that may still remain. Why does TM and the commissioner's affidavit, again, commissioner's signature again appear here, adjacent to 7.4 and 7.5?
Because again, the commissioner's signature and my original signature are the same signatures that were in the document of the 25th. Nothing changed. It's the same document. And the only change is in 7.3, where I indicate the corrections made.
Right. Sepo, follow the initials again. I'm gonna go. Again, 8.3. You have a TM there because you've made a change, correct? A handwritten change.
Yes, ma'am.
The TM and the commissioner's affidavit, is your evidence the same as to the reasons why that appears there?
It appears there because it was always there from the 25th. Yes.
Right. Sepoko. Next one. Just go up. Yeah. There's another TM next to 9.6. There appears to be a handwritten change there. That again is you, correct?
Yes, ma'am.
Right. Go down, Sepo. And that's your signature and a TM because you corrected your name, right?
Yes, ma'am.
And we of course see that this is the same statement of the 25th of February that was signed in Stellenbosch that we spoke about earlier, right?
Yes, ma'am. I affirm that nothing changed insofar as the original signatures were concerned.
So, Advocate Madonsela, is it correct then to say that the change is made on the 25th, on the copy of the 25th of February affidavit was signed or initialed not just by you, but by both you and the commissioner? Is that correct?
No, ma'am, it is not correct. It's not true.
Your evidence is that those changes, those handwritten changes on that copy were signed by you and you alone, right?
Yes, ma'am. That's why I wanted a withdrawal of the attack on the colleague who was Commissioner of Audits, because there was an insinuation that he's a criminal.
Right. Now let's deal with your affidavit of the 28th of February 2023, page 482, Tsapo. So Advocate Mbofu suggested that this affidavit was flawed or defective in some way because it wasn't initialed by the commissioner on every page. Do you remember that?
Yes, ma'am.
So when he was asked to refer the committee to the law that makes this a requirement, he referred the committee to section or to regulation 4 subsection 1 of the regulations governing the administration of oaths or affirmation. Tsepo, put that up, please. Yes, that's the one. Let's go to the section that Advocate Mpofu referred the committee to. You referred the committee to Regulation 4, subsection 1. Can you indulge me, please, Advocate Madonsela, and read Regulation 4, subsection 1 into the record?
Chair.
Thank you, ma'am.
Just before you do that,
below-
before my apology, Advocate Madonsela, just before you do that, I have a hand.
Yes. No, thank you,
Advocate
Chair.
Mpofu.
No, I wanted to know if this witness is also being called as an expert in law. If she is, then she should be qualified so that we can then deal with her as such.
Thank you. The witness is being asked to read the document. Advocate Mayosi?
Yes.
No, Chairperson. Sorry, Chair.
I'm with Advocate Mayosi now. If you're raising
but
a
he was
hand, I'll
talking
come
here.
back to you. If you raise a hand, I'll come back to you.
Yeah,
Yeah, you've got to allow the flow of the meeting so that it's not you who must be listened to.
no,
Thank you.
Chair.
I'll come back to you. Advocate Mayosi?
Chair,
Chairperson, I'm objecting, yeah.
Advocate Mayosi?
Chair, the witness is being asked to read this section into the record. This is in direct response to Advocate Mpofu having brought this very section of the regulations to the attention of this committee and having relied upon it when he was asked specifically to show the committee what he was relying on.
Thank you. Advocate Mpofu?
Thank you, Chair. Yeah, no, that obviously is so. That's not the point I'm making. I think she's missing the point. The point I'm making is, you'll remember, Chair, that after lunch, I came back after I had been asked, I think by one member, two members and Advocate Mayosi, and I told them that I don't keep every section in my head. And I addressed you on the sections for you to note. That's it. I never addressed that to the witness or through the witness, because if I wanted to deal with the witness as a legal expert, then I could have canvassed it through the witness, which is what she's doing. That's exactly the point I was making. Legal argument will be made when the time comes for legal argument. But and there's nothing wrong if the witness is an expert in interpretation of statutes, in putting it. I'm simply saying that then she must be qualified as such so that we deal with her as an expert in the interpretation of statutes.
Thank you, Advocate Mpofu. I'm still not connecting with the expert argument. Advocate Mayosi, then I go to Advocate Madonsela.
Thank you, Chair. Also, I'm not asking the witness to interpret anything, but thank you, Chair. I'll proceed.
Just before you proceed, then, Advocate Madonsela.
Thank you, Chair. I thought this was my opportunity to
flag the
read,
document, Tsepo.
to read the document.
Yes. Regulation 4, subsection 1. Please, Advocate Madonsela.
Thank you. Regulation 4, subsection 1 says, below the deponent's signature or mark, the Commissioner of Oaths shall certify that the deponent has acknowledged that he knows and understands the contents of the declaration and shall state the manner, place, and date of taking the declaration.
Thank you. Thank you, Advocate Madonsela. Tsepo, now take us to the affidavit of the 28th of February to test that affidavit against what section 4, subsection 1 says. Go to the end, page 485. Now, what you've just read of regulation 4, subsection 1 is that what the Commissioner of Oaths must do is that he shall certify that the deponent, being you in this case of this affidavit, has acknowledged that she knows and understands the contents of the declaration, and that she shall state, the Commissioner that is, the manner, place, and date of taking the declaration. Has this been done by the Commissioner in relation to this affidavit? Advocate Madonsela?
Yes, ma'am.
Let's go back to the regulation, Seppo. I'd like us not to just look at regulation for subsection 1. Can you also just read regulation for subsection 2 into the record, because it talks specifically to what a commissioner of oaths shall do in signing a declaration? Can you read those for us, please, Advocate Madonsela?
Thank you, Advocate. Subsection 2 says, the Commissioner of Oaths shall sign the declaration and print his full name and business address below his signature, and B, state his designation and the area for which he holds his appointment or the office held by him if he holds his appointment ex officio.
Thank you. Go back to the affidavit of the 28th of February, Seppo, page 485. And my question again to you, Advocate Madonsela, has the commissioner done what is required of him in terms of regulation for subsection 2?
Yes, ma'am, he did exactly that. As you can see, the stamp and also affirmation of his presence.
Right. In your evidence yesterday on this issue, you made mention of a case in the Western Cape High Court. You mentioned it during your evidence, but you couldn't elaborate on it. That is the case of Minister of Safety and Security and others versus Mohammed, right?
Yes, ma'am.
Chair, the citation for this case, for the assistance of the committee, is square brackets 2010 for all SA 538 brackets WCC, Western Cape High Court, a judgment that was delivered on the 30th of April 2010. Can you tell the committee, Mr. Advocate Madonsela, please, what the relevance of that case is to the issues raised by Advocate Mpofu in relation to your 28 February 2023 affidavit?
I think the essence of the Mohammed case is simply that an affidavit or a document so signed is not invalidated simply because the signature or not the signature, the initials of the Commissioner of Oaths are not on every page.
Thanks. I've taken the liberty of making a copy of the case. Seppo, can you put it up, please? Yes. That's paragraph 26 of the case. And as Advocate Madonsela has alluded to, the issue that this paragraph was dealing with was the legal status of an affidavit where that affidavit does not contain the initials of the Commissioner of Oaths and on every page. And there I'm reading the bold and underlined, although it certainly is the practice for both the deponent and the commissioner to initial all pages of an affidavit on which their signatures do not appear, this practice is not a requirement for the validity of the affidavit. It is not required by the rules governing the administering of oaths and affirmations that are set out in the regulations promulgated under Section 10 of the Justices of the Peace and Commissioners of Oath Act 16 of 1963. Is that what you were referring to, Advocate Madonsela?
Certainly, and thank you for the opportunity to present it properly.
Now, the section, regulation for subsection 1 that was relied upon by Advocate Mpofu, does it say that a commissioner is required to sign, to initial every page of an affidavit that is presented to him?
No, ma'am, we just read it. It definitely does not say so.
Thank you. So just to move quickly along to the second issue that I said I was going to deal with today in my interaction with you, and that's the issue of the motion. So let's turn to the motion. Seppo, put it up, please. And I just want to point out two things at the outset, Advocate Madonsela, relating to the motion. Just for you to get a sense of the approach that the evidence leaders will follow relating to you and the motion, and the reasons for that approach. So two things. The first one is that engaging in it is the understanding of the evidence leaders that engaging in a competitive exercise between Advocate Mkhwebane's conduct and that of her predecessors, including yourself, doesn't form part of the mandate of this committee. So my interaction with you is not going to involve that. Do you understand that, Advocate Madonsela?
Thank you, ma'am. That was what I had been assured of.
Yes, the second point I'd just like to point out up front is that there's already evidence before this inquiry on the aspects of the motion that mention you in relation in particular to CIX and Vrede. So the fact that there's already evidence, coupled with the length of time that has passed, coupled also with the fact that you told the evidence leaders that you no longer have access to records. These issues are the reasons why the evidence leaders determined that it wasn't necessary to call you for oral evidence. And the contents of the statement that you recently filed didn't change that determination on the part of the evidence leaders. Are you with me, Advocate Madonsela?
Certainly, ma'am, I am. Thank you.
Yeah, but you're here now, Advocate Madonsela, and be grateful for that. But for all these reasons that I've just asked to put up front, I'm going to be very brief with you when it comes to the motion. Are you with me again?
Yes, ma'am.
Yeah, so let's turn to the motion. Starting with charge one, which is where Advocate Mkhwebane is alleged to have committed misconduct in relation to various things which it is said she did or failed to do in connection with the investigation, report, and litigation in the sub-CIX matter. You see that?
Yes, ma'am.
So go down to paragraphs 1.1 and 1.1.1. Yeah, 1.1.2 and 1.1.3, starting with 1.1.2. There, it is said that Advocate Mkhwebane, amongst other things, his conduct was objectionable because she materially broadened the scope of the investigation in the final report as compared to the provisional report without giving notice thereof to any affected person and without furnishing any explanation. Therefore, do you see that?
Yes, ma'am.
And it is also said in the next paragraph, 1.1.3, that she materially altered the remedial action in the final report as compared to the provisional report on the instruction and or advice of the presidency and or the state security agency, and without giving notice and an opportunity to comment thereon to affected persons. You see that?
Yes, ma'am.
Now, the evidence that is already before this inquiry, and which you've now also confirmed in your affidavit, and I think this is fairly uncontentious, is that you left no approved or signed off provisional report when you left the PPSA in October 2016, right?
Yes, ma'am.
And the final report in this matter was issued on the 19th of June 2017, more than 18 months after the end of your term, right?
Yes, ma'am.
So the comparisons between the provisional and final reports that are referred to in these paragraphs, in these charges, these would be comparisons of provisional and final reports issued by Advocate Mkhwebane and not you, correct?
Yes, ma'am.
Chair. Okay. Firstly,
Yes, Advocate Mbofu.
apart from the futile attempt to amend the charges, that cannot be put as a leading question, because once again, it's evidence from Advocate Mayosi, which is completely worthless unless if it's given under oath.
Thank you. Advocate Mayosi.
And subjected to cross-examination.
It's on the record, Chair. You can ask the questions differently. It is your evidence that you didn't issue a final report, correct?
Yes, ma'am. And I said so yesterday as well. It's just a confirmation.
And it's common cause on the record that Advocate Mkhwebane issued the final report in June 2017, correct?
Yes, ma'am.
You didn't issue a provisional report, as you stated in your evidence, and it's on the record that a provisional report was issued on the 20th of December 2016 by Advocate Mkhwebane, correct?
Yes, ma'am.
Thank you. So the comparisons are not in relation to reports issued by you, correct? It follows.
Yes, ma'am.
Thank you. Can we move?
Chairperson,
Just pause, Advocate Mayosi. Advocate Mbofu.
yeah, surely Advocate Mayosi must know that she can't do what she's doing. Surely. If you know,
What am I doing?
Sorry, yeah.
you can't
Before
put
you
a
come in.
conclusion to a witness, a legal conclusion that you seek to draw. You can argue it at the end. You can't put it to a witness. What's the witness supposed to say? Just a prop. This is not generations. So she must just say yes, yes, and to your evidence.
Chair, no legal conclusions were drawn here. These are factual conclusions based on the common cause evidence and based on the witness's confirmed evidence. Let's move on to the Friede dairy matter. Sepo, please put it up. It's the motion. It's the motion. And again, this is a charge of misconduct in which Ms. Mkhwebane is again alleged to have committed, to have done various things or to have failed doing various things in relation to the investigation, the report that was issued, and also the litigation, the ultimate or subsequent litigation in the Friede dairy matter. Are you generally familiar with this charge, Advocate Madonsela?
Yes, ma'am.
It then proceeds to have subparagraphs which, as do all the other charges in the motion, which describe what it is said Advocate Mkhwebane did or did not do in relation to the Friede matter. In paragraph 4.4, it is said that Advocate Mkhwebane materially altered the remedial action proposed in the provisional report prepared by you before issuing the final report without providing any rational or proper explanation therefore. Do you see that?
Yes, ma'am.
Now, you testified yesterday that you didn't leave a provisional report in this matter, correct?
Yes, ma'am.
Is it also your evidence that you didn't leave a final report either in this matter?
Yes, ma'am, it is.
Sepa, please go to bundle A, page 1273. Bundle A, you've got it. Let's go down slowly. Go up. Yes, that's fine. Advocate Madonsela, this document, which is on the record, is a provisional, says it is a provisional report on the investigation into complaints of maladministration against the Free State Department of Agriculture in respect of non-adherence to Treasury prescripts and lack of financial control in the administration of the Free Dairy Project. So in short, it suggests that it's a provisional report in relation to the Free Dairy Project. Do you see that?
Yes, ma'am.
Go down, Sepo. Stop. So there at the top, there's a line that reads invisible oversight, provisional report by the public protector dated November 2014. Do you see that?
Yes, ma'am.
You were still the public protector in November 2014, correct?
Yes, I was.
Go to page 1351, Tsepo. The last page. Yeah, go down. Yeah. Do you see that this document obviously has your name in it as the public protector, and this, I think this is also part of the evidence before the committee. Advocate Cilias was part of this investigation. Do you see that?
Yes, ma'am.
It's an unsigned document. Are you able to tell the committee at all what the status of this unsigned provisional report is?
It was not a provisional report in the status of a provisional report of the pub protector. In other words, it had neither been quality assured by the quality assurance team, nor signed by me. When you see those initials appearing, all draft documents of the pub protector have that, although we had advised team members to stamp draft on documents, but it was a new practice. So you'll find every draft report, no matter how rudimentary it is, it would have the initials of the pub protector and the investigators that are working on it.
Was this, I mean, you've testified that you never left a provisional report by the time your tenure ended. It's correct, is it, that you never signed off on this report?
Certainly, and my evidence yesterday, you will recall, if you may, ma'am, was that I then asked Mr. Samuel to take over this investigation, and he certainly went there after these elevations had been prepared.
So yesterday, Advocate Mpofu, I think in relation to this issue, asked you a question to the effect that it would be illogical to then conclude that you had left a provisional report behind, to which you said that it would be untrue that this was so. Is that your evidence?
It still is, ma'am.
It would not be true, I think you said. You struggled with his use of the term illogical. You preferred it would not be true. Is that right?
I did, ma'am, because it depends on the context. If the facts appear to logically connect, you would arrive at a particular answer. It's not illogical on what appears to be facts. And then, of course, if later you realize that what appeared to be facts are not facts, then it just becomes untrue.
So if a representation or a statement is made in an affidavit or anywhere to the effect that this November 2014 report was a provisional report issued by you, would that be false or would that be true?
That would be definitely false. A provisional report is a signed document by the public protector.
Okay. I don't have any further questions for Advocate Madonsela, Chair. Thank you, Advocate Madonsela.
Thank you, ma'am.
Thank you, Advocate Mayosi. We are now, as we wrap up, I'm going to ask Advocate Mpofu to come back for any pickup questions as we wrap up. Thank you.
Thank you, Chair. Good morning. Thank you. Good morning, Ms. Madonsela.
Good morning, Advocate Mpofu.
Thank you very much. Yeah, I'm just going to do some pickup questions, but I just wanted, Chair, you saw my hand. I was trying to raise when Honorable Gondwe was asking questions, but I thought to save time, let me just deal with those issues now up front here. Just to assure you that the record will show that there's no evidence here that has been led that SSA was actively involved in the operations of the public protector. Neither is there any evidence that just a minute, that Advocate Malunga was sidelined because he did not have security clearance. That's just for the record, but we'll deal with that maybe when we summarize the evidence. Yeah. All right. All right. I think Advocate Madonsela, let's sorry, you'll forgive me. That's how we are used to addressing you. I think let me just start with the issue so that we get that out of the way. The issue of the affidavit that Advocate Mayosi dealt with. And particularly from, I know that you and I differ on the adage that context is everything, especially in interpretation. But I don't want to spend more time on this than is necessary. I want to take you to page 490. That's your first statement. Yes, can you go to, sorry, it's my fault. 193, I think, is the last page. Yeah, further down. Yeah, okay. Up a bit. Yeah, right there, right there. Okay. Now, you've been taken through the dynamics of the statement, so I don't want to waste time on it. I just want to refer to two important features. This statement, you know, firstly, you signed on top of the name, correct?
Yes, Advocate Mpofu.
Yes, and in fact, you misspelled your own name there, correct?
The person who typed it for me misspelled it. And we
Yes.
were in a hurry. It was Saturday, the deadline was at 4. I didn't see that. I was trying to chase the deadline.
Yes, that's fine. Okay, then let's go to then the bottom. The date was the 23rd of February, 2023, the original date, correct?
The Commission of Oath mistakenly put 23rd. Then he realized he had made a mistake and put 25th and therefore changed it.
Yes, good. Okay, that's fair enough. And then because he made that change, then he initialed that change and made a mark there, correct?
Yes, sir.
And you made a mark against his mark, correct?
Yes, sir.
And that is to confirm that that change has been effected by both of you in the presence of both of you on the 25th of February, 2023, correct?
Yes, sir.
And you did that irrespective of the fact that on that same page, both your full signature and his full signature appear there, because that was for a different indication. The mark was for a different purpose, correct?
Yes, sir.
Yes, okay. So do you now understand what regulation 4.1 means when it says when there's a mark of the commissioner, there's also the mark of the deponent?
No, that's not what it says, sir.
Okay, what was the purpose for, all right, what was the purpose for those two marks that you made there?
We made a choice, given what the Mohammed case says, we were not required by law, but we made a choice with this Commission of Oaths, because this is a different Commission of Oaths. We made a choice to sign together, or he made a choice because he was in charge of this process of the signing, as commissioners of oath are. He made a choice that I should sign next to him.
All right, yeah, but what
It was not legally compulsory in terms of Minister of Safety versus Mohammed.
No, Minister of Safety versus Mohammed has got absolutely nothing to do with what we're discussing. I'm asking about the Minister of Safety, and Mohammed talks about signing every page. I'm not talking about that. I'm talking about the corrections you made, the marks you made on the change of date. What's that got to do with Mohammed?
Okay, sir. Minister of Safety versus Mohammed has nothing to do with what you are talking about.
Yes, thank you. All right, that's fine. Okay, fine. But you do, okay, as I said, I don't want to spend much time on this. All I'm saying is that despite the fact that both your signatures in full appear on that page, you both found it necessary to sign and countersign against the alteration on the date. All right.
Exactly, which has nothing to do with either the regulation or the Minister of Safety.
You just did it for fun.
We made an election, or he made election, and I complied, which is what Minister of Safety versus Mohammed says.
No, Minister of Safety and Mohammed says something about alterations on affidavits, in your estimation?
No, it says nothing about alterations. That's why I do. Neither does the regulation that you cited say anything about alterations. That's why I don't quite understand. Maybe you should repeat your questions there, because I don't know what you're trying to say. I don't know what you want me to answer.
Just answer the question. You don't have to know what I'm trying. I'm not trying anything. I'm asking you a question. You just answer it truthfully and honestly, as you saw at the beginning of these proceedings. Okay, let's go then to the next statement. That's the one of page 486. Now, let me ask you this. You know that these proceedings are very important in the history of this country and unprecedented, correct?
Absolutely.
Yes.
All proceedings are very important as far as I know. That's how I handled my cases as a court protector.
All right, that's fine. Okay. But you do know that in posterity, people will look back at these proceedings probably as a reference point when any impeachment or if any impeachment occurs, because well, you might not know the history of how the rules came into being, but at least it's predictable that this will be a reference point, correct?
I really don't know. It might be immediately superseded by another precedent. I really don't know what the future holds there.
Yeah, no, that's fine. That's fine. All right. Now, tell me, if somebody in 100 years, not now, comes across the affidavit 486, comes across that affidavit, okay? And they read, you explained this on page 486, yeah. There's the 2 marks and a mark below. Let's go to the next page because that's the more important one. Yeah, start at the top. You've changed that. There's an insignificant change. You changed the word summons you. It was your to you and remove the R, correct?
No, sir. Please, you must read the originals before you make these allegations.
Okay, what were you signing against there?
But
when
really, you should have read it before you make accusations, sir.
Advocate,
Just a sign there.
Miss, whatever you are, please answer the question. What were you changing when you signed next to that at the top of that page?
I was changing the sign, the accidental sign that in the computer is in the same space as a period. That was the sign there. And it was shown this morning, sir. Are we going to rehash something that was shown to this committee this morning?
Please answer the question. What were you changing when you signed?
I was changing what was shown to this committee this morning and was adduced by Advocate Mayosi, which was a sign that is in the same key on the computer as a period sign.
So why are you answering differently from what you were answering when you were asked by other people? What's so difficult about telling the committee what you were changing? So it was a period, okay, and you signed against it. And then at 7.3, what were you changing there?
Sir, I'm not answering you differently. You firstly, on the record, said I changed an R. I said to you, I didn't. So to my colleague earlier, I answered yes and no when she was showing things on sign. She never accused me of things that I hadn't done.
Okay. What were you changing at 7.3?
As you can see, there's Paul Hoffman, and out of respect and professional courtesy, I thought we have to say Advocate Paul Hoffman, SC.
Yes. And okay, sorry, just go back to paragraph 5, sorry, Tsepo. And paragraph 4, there you were changing, I think, let me rather lead you. You were changing a small letter C to a capital letter C, correct?
Yes, sir.
And then in the next one, at paragraph 5, that was not a cosmetic change like the others. It was changing the date from the 1st of February to the 21st, correct?
Yes, sir.
Good. So we can safely say, and then 8.3 again is just you're changing a Y. I'm sorry, or a letter. I'm scared now of even identifying the letter. You're changing a letter of the alphabet at 8.3, taking it off, correct?
No, sir. It doesn't take a letter of the alphabet. As can be
Yes.
seen in the version that was aired this morning, it was the, which is THE, which was
Yeah.
changed to they, which is THEY. So a letter was added.
Okay, so you're adding a letter of the alphabet. And then at 9.6, you are taking out a letter of the, or you are adding a letter of the alphabet S, correct?
Yes, sir.
Right. So we can safely then say that that was a collection of, let's call it, one substantive change, and some of them just grammatical or spelling changes, correct?
Yes, sir.
Right. Now, I'm saying, and I'm saying this in relation mostly to the substantial change. Oh, and then of course, you also changed another letter of the alphabet on your name. It was no longer Nomkoso Madonsela, but Nomkosi or Nomkoso 1, whatever you're changing the letter O to I suppose, correct?
Yes, sir, which is aligned to the heading of this affidavit.
Yes, right. So those changes, now I'm saying, if someone reads this affidavit, all right, let me just make it, all these changes you made here, substantial and not so substantial, you did them on the 28th of February or the 1st of March, correct?
Yes, sir.
Yes, what? Which one is it?
Well, the changes were done by me before the 20. I must have done them on that Sunday when I came back from some event, but could only then have a commission of oath for the electronic version much later.
Okay, good. So you did them on the 26th of March, or rather, sorry, of February, according to you. And then they were only commissioned on the 28th. Right?
Effectively, this affidavit, when it was submitted, was not meant to be the affidavit. So
Yeah.
my understanding is that before this committee, there are two versions of the affidavit.
Oh, I thought there was one.
Can I just finish? Because this was what I said in my email, isn't it? There are two versions of the affidavit. I'm submitting the electronic, but for ease of reference, I'm also adding the hand changed one, so that because of the speed with which things needed to be done, it should be easy for the committee to look at the version of the 28th and say, where have the changes happened? I was trying to prevent the hullabaloo that ensued when a belief was entertained that the affidavit had been changed and it was now a 9-page document. So I wanted to keep it clear, this is the change, but what I was submitting for this committee's consideration was the electronic version that was again read this morning.
Yeah, well, that cannot be true, madam, because the hullabaloo that you're referring to only occurred after 10 o'clock or after 10:30. You did this, you say, on Sunday, 2 days before, or were you predicting a hullabaloo?
No, I was trying to prevent the hullabaloo, which happened anyway, because my intention was to not stress this committee by submitting a new affidavit.
Yeah.
We, number one, an affidavit has to be submitted 7 days before parties. So I'm submitting a new affidavit that for all intents and purposes satisfies the requirements of an affidavit. But for this committee to entertain it without stress, they needed to know what's the difference between that affidavit and the one of the 25th.
All right.
Thank
Okay.
you,
That's fine. So, okay, for now, let's accept that as your explanation. But you would accept that somebody who reads this affidavit 20 years, 30 years from now will make the following conclusion: that there is an affidavit which has those changes, and those changes, at the bottom of that, there's a signature of the Commissioner of Oaths, and therefore those changes were made on the 25th of February, 2023. You would admit that, correct?
No.
Okay. Now, okay, so if someone walks in now where you are there in Stellenbosch and takes this affidavit, looks at it, sees all the changes, 1st February 2023, and everything there, and then at the bottom it says Tulisile Nomkosi Madonsela, and then it has a sign of Commissioner of Oaths, 25 February 2023. When are they going to think those changes were made?
Well, I don't know. I think a reasonable person would inquire.
No.
Are we talking about a reasonable person or an unreasonable person?
I'm talking 100 years from now, we will all won't be here. I'm saying that reasonable person who picks up this affidavit, when are they going to say those changes were made?
I think they might think about these changes in multiple ways. If they think in complexity terms, as I expect reasonable people, especially lawyers, I would think that they might think it could have happened anytime. And if they were reasonable people, they would inquire. They would not assume.
Okay, let's say a judge then, who's prima facie a reasonable person. If a judge sees this affidavit like this with all these changes, when will he or she think that they were made?
I would expect a reasonable judge to want to know who made them, because a reasonable judge would want to know the genesis or genealogy of the affidavit. Because in fact, a reasonable judge would be like me as a pub protector, because as a pub protector, I knew people could manufacture documents. I would therefore never presume when things happened. I would investigate.
I see. But you do accept, at least since you don't want to answer that question, you do accept that when you make these signatures and marks and all that, it's really not for your own edification, it's for the reader out there. A judge or whoever might read this in 100 years or 200 years time, or the chairperson or whoever will be reading the record. Let's assume there'll be a review, whoever might be reading a record. When you sign there, you're signing for that, you're communicating outwardly to somebody else, correct?
Say no, I don't sign or write for. I disagree. I don't sign or write for posterity. I write to communicate with the people that I'm communicating with. And that's why I took extreme care to send 2 versions of the same document so that they would not be confused as to this clean document, which had been properly signed according to the Mohammed case, but now they would have to wonder, what's the difference between this one and the one we received on Saturday? So I was communicating with those people, and that's what I do. I never do anything for the public. I don't play to the gallery.
Okay.
I
Okay,
am
thank you,
present
Advocate
where I am supposed to be.
All right.
Thank you, Advocate Madonsela. I just have two hands. Just a pause, Advocate.
Okay,
Mpofu.
Chair.
Advocate Mayosi.
Yeah, Chair, thank you. I'm just struggling with this line of questioning. Given the current context of this affidavit to these proceedings, I'm struggling with what relevance it has, what a reader might think of it in 30 years' time.
Okay.
You drop your hand. Okay. Yes, Advocate Mpofu.
Yes. No, Chair. Well, I'm not here to cure Advocate Mayosi's struggles, but the reason why I'm asking the question is that the affidavit, the document that we're reading, although the witness is evading the question, is any document like this, Chairperson, when you sign, that signature is meant to communicate something to somebody, at least I hope. You don't just sign, you're signing to say to whoever reads the document, because you can't, when you read affidavits, you don't go back to every time you read an affidavit in a court case in the constitutional court or whatever, then you have to go and inquire from the people who signed that document. That's just absurd, yeah. So when you sign an affidavit like this, you are communicating to the reader, really, something, whatever it is that you want to communicate. And for example, when they signed with the Commissioner of Oaths against the change of the date, they're communicating to whoever it is that although it might look like the 23rd, now it looks like 25th, but we corrected this, and then we all know. That's how I know. I wasn't there. I know it because I can read from this. So the question is very simple, and the witness knows the answer, but she chooses not to answer it. That when you read this affidavit, you will know, or at least you will read that there were corrections made, yes, and they were made on the 25th of February, 2023. But that will be false, because on her new version now, they were made on the 26th. So we now have three versions. One was done on the 23rd or 25th, whichever is the correct one. The second one on the 26th, and the other one on the 28th. And that's all I'm trying to portray. It's very obvious, actually. But if Advocate Mayosi is struggling with it, well, there's very little I can do.
May
Okay.
I respond? No, Advocate Mpofu, you said yesterday you're not going to make an allegation and then leave me dry. So
I
may I
didn't
respond?
Chair, why are you addressing me? Chair, I've
Okay,
not asked.
Chair, may I please respond?
Chair, I've not put any question. I'm going to put the question now. So then you'll respond to the question, ma'am. Okay, maybe just for your assistance, I was going to move to something else so that I give you an opportunity to respond. You, Advocate Madonsela, are disputing the fact that anybody reading this document would be left with the impression that these changes were made on the 25th of February, 2023, which impression would be false. Is that your evidence so that we can move on? Yes, okay, good.
I don't think people
now
have
you can explain,
mind.
sorry. Yes, you can explain. Yes, ma'am.
I don't think everybody has a single mind. Firstly, just going back to, if I communicate with intention to convince the person I'm communicating with, then I agree with you, because this was sent in communication with the evidence leaders, and it was also sent to the legal team. So a reasonable person would take this document with the email that was sent to them to say, we are sending you two documents. And because this document was not even, at the time, it was really the sort of photocopied. And therefore it became one document with all of with the final document. So a reasonable person would read the email first and understand, okay, the document that is being proffered as the affidavit is the corrected version of the 28th, properly signed by a commissioner of oaths. And then this document is not being proffered as a document to be relied on because it's only telling you, the owner of the electronic version, what are the changes. So a reasonable person would want to know the context, and chances are they would find these documents together. Of course, an unreasonable person, I cannot be held accountable for how an unreasonable person would twist a simple matter into a complex matter.
Okay, so only an unreasonable person would think that the 25th of February means the 25th of February. Okay, and all this, what you're saying, would come from your email, which simply reads, "Dear colleague, kindly receive an edited version of the affidavit. I apologize for the errors in the initial one." Or what you've just said, you say, is encapsulated in that email, correct? For the reasonable.
A subsequent email indicated what is the relationship between the two documents.
All right. Okay, ma'am. Let's move on. That's fine. I think the facts speak for themselves. Now let's come to your favorite.
No. Wait, Chairperson, a reasonable person.
Madam, please let me finish. Then you can interrupt.
Okay, let me pay attention to Advocate Madonsela.
I'm saying a reasonable person would not split a document, because just as when the document was received, it was thought to be a 9-page document. Honestly, good people, a reasonable person would look at the document and realize that it's not a 9-page document, it's 2 documents. And they would want to then understand what is the relationship between the 2 documents. I therefore deny what Advocate Mpofu you are trying to do here. Are you trying to run away from the fact that yesterday you misled this committee about what is required to make the affidavit of the 28th an affidavit, and you're now shifting the goalposts to the corrected affidavit?
Thank you, Advocate Madonsela. Advocate Mpofu.
Well, Chair, I don't know why you want me to say anything, because I don't know what the witness was responding to. I just uttered 2 words and you allowed her to interrupt me.
She wanted to address the chair and I've allowed it.
No, she was responding to what I was saying.
She asked for a permission to speak and allowed her.
In the middle of my question. Okay,
Like
fine.
Anybody does.
No, it's fine. I want to ask that question again, because you and the witness seem to know what the question was and even the answer. All right. No, it's fine, ma'am. Let's move on. I won't ask you what I was trying to ask you because you interrupted me with permission. All right. Now let's move on then to your favorite topic, the one you're saying I'm running away from. Sorry, Chair, I'm just looking for my judgment. Right, that is do you persist with your version of yesterday that you are not aware of the practice that both the deponent and the Commissioner of Oaths sign every page? Or are you aware of that practice?
Advocate Mpofu, you are distorting my words once again.
No, just answer the question, ma'am. Don't insult me.
I don't persist with a version that I never offered, say.
Yeah, then say so. You don't have to insult me, madam. You just say yes or no, and then I give your explanation. There's no need for you to insult me. I feel nothing to be insulted by someone like you. So just don't do it. Just answer the question.
But
sorry,
Chair?
Pause, Advocate Madonsela. Advocate Mpofu. Yesterday I did ask that the language is toned down.
When I speak, the language was, you allow me to.
Are you going to
insert it?
listen to me,
No, ma'am.
Mr. Mpofu? Are you going to listen to me? And once I do this, I'm going to ask you to wrap up also. It's not proper that you use such language in this inquiry. To even go on and say you're not insulted by somebody like you. It's really not in the space of parliament that we can allow that. Yesterday, she used a language that says it's another low to you, and I called her to tone down and stop doing that, which she did. I can't allow this to continue in the same inquiry. So I'm asking you to please tone down the language.
Anyway, okay, Chair, you are completely unfair because you allowed her to say something about my standards and what have you. Now you are, up in arms to defend it. That's fine. Ma'am, let's just come back to the business of the day. I'm saying that the case of Mohammed also refers to the practice of signing on both pages. You aware of that?
Yes, I am. I cited it yesterday, sir.
No, you okay.
Just before you proceed. Okay, I was just going to ask you to switch on your video because it was off.
Okay.
I was not sure what was the difficulty. Thank you. Proceed.
Thank you, sir.
Yes. And are you also aware of the practice referred to in that case?
I am aware, sir. Yesterday, you didn't ask me about the practice. You said to me, you are a public protector, and in all of your years as public protector, are you aware of any case where the Commissioner of Oaths and the deponent did not initial every page together? I said, I don't know. I didn't check everything, and which means I was right, that there may be cases where it wasn't done, hence the Minister of Safety versus Mohammed case.
All right.
This case would not have happened if there hadn't been instances when somebody didn't do it.
All right. Okay, ma'am. So, okay, fine. At least now you are aware of the practice. Firstly, that's not what I asked you, but that's fine. The record will speak for itself here. Let me just assist you as to what I was talking about. Or at least do you accept that let's do it like this. You remember me saying yesterday that that question was not aimed at a question of validity. You remember that?
Oh, it wasn't, because throughout you were talking about illegality, and if it's illegal, according to the law, it's valid. That's the principle of legality.
Oh, ma'am, please, man, listen to the question. Please, I'm begging you.
Okay.
Did you hear me yesterday saying that when I raised these 4 or 5 pointers, it was not only about the question of validity? Oh, you didn't hear me. If you didn't hear me, you didn't hear me.
Oh, please repeat yourself, sir.
For the 3rd time. Did you hear me yesterday when I said some of the issues I was raising had to do with the, let's call it, the conduct of the Commissioner of Oaths and you as the deponent, and not only about the validity of the affidavit?
Oh, I heard you malign the 2 colleagues that signed and suggested there may be some criminality. Is that what you're referring to, sir? If not, please repeat yourself. What exactly did you say? Just refresh my memory. You said a lot of things, sir.
That's fine. No, it's okay. I can't repeat it for the 4th time. Yeah. Anyway, the 2 colleagues that signed, and I heard you malign the 2 colleagues that signed and suggested there may be some criminality. Is that what you're referring to, sir? If not, please repeat yourself. What exactly did you say? Just refresh my memory. You said a lot of things, sir.
Anyway,
the law is very clear on this, that when it comes to a question of validity, something might be allowed, but there is an established practice. And that practice, I think you and I went through it, among other things, is meant to prevent forgery or someone manipulating other pages and so on. That should be obvious. That's why we initial every page, correct?
You said that, I think, or something to that effect.
Yes, yes. Do you agree with it?
It is to authenticate, and of course, each circumstance differs from another. In this particular case, having with the commissioner, having the original and having the original signed by another commissioner and me being present there made it just easier to quickly do this and running against time. So yes, the practice, I guess, has a reason. Everything has a purpose, but there are outlying situations as happened in the Mohammed case.
Yes. Okay. Well, the evidence leaders seem to suggest to support your you and the commissioner's deviation from that practice. And I just want to tell you that the evidence leaders, just as a matter of interest, in this committee have presented statements where both the commissioner of oaths and the witness signed on each page. And that includes the person you called the young investigator. The following statements are signed by the commissioner and the witness on each page. Statement of Mr. Tebucho Kekana, dated 18th July 2022. The statement of Mr. Vusi Mahlangu, dated 2nd August 2022.
Just a pause. Suppose, Honorable Milam, there's a point of order.
Thank you, Chair. Chair, I'm sorry to interrupt Advocate Mpofu, but we've now listened to this go on for 4 hours about the affidavits. And frankly, I'm at the end of my patience on this. We know the issues, we've ventilated the issues, we've heard the various responses. We know what the concerns are that Advocate Mpofu has with the affidavits. We know Advocate Madonsela's response. I fail to see what going through it another time accomplishes. We know the law, we know the situation, and we've now spent over 4 hours on this one issue. Thank you, Chair.
Thank you, Honorable Milam. Advocate Bauer.
Chair, we will confirm as evidence leaders, we followed the practice. I can, if you wish to say this on other occasions, I haven't followed the practice.
On that, just hold because he's not complete. I want him to conclude.
Thank you, Chair. I think this is just a waste
note of your intervention, Honorable Milam.
Yes, thank you, Chair. Yeah, well, this a waste of time in the name of saving time. Yeah. The statement of Futana Tebele. 4, the statement of Baldwin Nashunji. 5, the statement of Liwani Chaulula. 6, Dicheni Raidani, Reginald Ndo, Basani Baloyi, Ponatseho, Ohalad Mundus, Tolan Torseng, Mutsizinelisi Watajane, Niels van der Merwe, Freddy Nyatela, Ronald Lamola, Bianca Mviana, and Mr. Siabi. All of them are signed on every page by the
do you want a response to that?
No, can I finish?
Yeah, please hold back, Advocate Madonsela. Conclude, Advocate Mpofu.
Right. In each of those statements, both teams that are here have caused and there's one exception just to be fair to you. There's one is Mr. Samuel had two statements. One of them was signed by the deponent on each page, other one was not. And the other exception is you, Advocate Madonsela. But on each of the names that I've listed to you, and we didn't pick up earlier because we only did this analysis yesterday, the deficiencies in Mr. Samuel's statement, but that statement is not what the paper is written on for other reasons. But on each of those statements, the teams here ensured that there is that. And the point I'm making, Chair, is a very serious one, which is that when whether it was the evidence leaders or ourselves, when we offered our assistance to you, Professor, then you could have been sure that from what I've just told you, that what you call the hullabaloo and you know, this what is annoying Mr. Milham would not have taken place, because I think this is ample evidence, whether it was them or us, the statement would have been done properly. Do you accept that?
No, I don't, because I don't know how you do things. There were mistakes in the letters. There have been mistakes in how you've read things here. So how could I have predicted you wouldn't have made mistakes?
Thank you, Adv Madonsela. We'll get your answer.
Thank you.
Advocate Mpofu, I want you in the next 6 minutes to wrap up, which will be 12:30. We're supposed to conclude at 12.
Chair,
Thank you.
No, well, I'm going to need more time, Chair. I need to deal with.
No,
that was just one. No, Chair, there was, okay, there were 3 segments of issues. One, segment A was the issue of the affidavit, which was dealt with by Advocate Mayosi. I've dealt with that. Segment B was
I want to assist you so that you don't waste any
no,
more time.
No, I'm not wasting time, Chair. Can I finish talking?
Please
Come on,
conclude, so
guys.
that I'm
Please.
going to make a ruling. Please conclude. Please conclude, Advocate Mpofu.
No, it's fine, Chair.
So I'm asking you to conclude at 12:30.
Yeah. All right. Okay. Madam, you, I think, did not answer the question that was asked by Honorable Holomisa. At least you said you don't hold grudges and so on, which is fine. But I think the gist of the question was whether you don't find it strange or you're not surprised that the same people who insulted you during the Nkandla debacle and called you names and called you a CIA spy, whatever, and still call you names and sometimes even objectionably referred to your features and all sorts of despicable things, and called you Makoti was a Stellenbosch and Tombe Bugekayo and all sorts of things, degrading names, that those people are now praising you. And I think the gist of that was not that you hold grudges. I think admirably you don't hold grudges, but the question was whether do you find it strange or expedient that those people are driven by expediency, that they are now suddenly your #1 fans?
May I respond to that? Chair, allow me to say that even by your standards, Advocate Mpofu, this was the lowest.
Chairperson?
You conceived as an advocate of the Supreme Court of South Africa to bring insults that have been into the public domain, into this.
Advocate Madonsela, just
yes,
pause, please pause. Please take a breather. I understand what the challenges are. I did ask you yesterday not to get to that level. And I'm
apologize, sir.
I'm asking again.
Okay.
I apologize and I withdraw.
Please proceed.
Apology accepted.
I apologize.
I wanted to
Mpofu.
conclude. I wanted to conclude. Please conclude
Yes,
your response, Advocate Madonsela.
Advocate Mpofu, I am shocked beyond measure that you, as an advocate of the High Court of this country, have taken slurs that have been said to me. A lot of the things that you've said have never been said in Parliament. The one slur about my looks that you have repeated in this record that you yourself have said you envisage to be here for 100 years. You have brought what President Zuma said about my looks in the streets into this record. That is shocking and that is unprofessional, sir.
Yes, thank you. Is President Zuma a member of the ANC?
It doesn't matter what he is. I'm just saying, sir, you've taken what a street fight and brought it here. Firstly, you have reduced my response to what was said. I didn't say that I have forgiven people or something. I said people change. You and I were on the same side on one issue because we understood the same. When you litigated on the Public Protector, we approached you to persuade you about our interpretation of the powers of the Public Protector. You accepted that and you used that and we won the case. Today you are on the other side because you have been persuaded differently. So my response, which I repeat again, is that it's not about I hold no grudges. It is about I am not surprised, because that was the question that I was asked, are you surprised? I am not surprised because I expect MPs and lawyers and reasonable people to change their mind when they get new information. What we do, I repeat again, Advocate Mpofu, depends on what we know, how we feel, what we think, then we act. And that changes every day. At least this is what neuroscientists say. So it's not just about I bear no grudges. It is about we deal with issues as we deem fit. And I am glad that MPs are not stuck in yesterday. They are here, right here, in this room, trying to make sure that South Africa works for everyone.
Yes, no, thank you. Well, for the record, I'm not on the other side. I'm just representing Advocate Mkhwebane. I don't regard that as being on the other side from you. But, and also, in case you missed it, the adjectives that I used about it being objectionable and despicable should show you that I don't agree with those epithets. For example, I don't agree that you are a CIA agent. I think that's ridiculous.
I disagree with you. You are elevating those things once again to this room and putting them on the record. Well, that is unprofessional, Advocate Mpofu. Shockingly, shocking.
No, that's fine. Well, you can insult me as much as you
like. Totally shocking.
I've told you that what that does, it's water on a dark speck. All right, you can insult me all day, ma'am. Now, as far as Friede is concerned, you say you thought and you considered that politicians should be investigated, and we now know that the Advocate Mkhwebane did not just think, but he actually went and investigated the politicians and also went to the site of the Friede dairy farm. Now, what I wanted to ask, I was going to give you references. I want now, because of time, of the conversation you and I had on the Section 7.9 responses of Mr. Mahashule and the MEC, which you had said you would, if you had seen those, you would withdraw the snide remark you made yesterday about their names disappearing. But because of time, we'll probably have, I was trying to avoid having to do that in writing, but we will write those to you and we'll submit your responses to the committee if the chair, in the interest of time, will allow. So that's just, I'm just informing you that, you understand, ma'am?
I fully do. And also about going to where victims are. I went to Cleveland's when nobody was going because it was the killing fields. Even my staff didn't want to go. So you're not going to say that because I didn't meet this particular set of complainants, that is a judgment on me. And again, Advocate Mpofu, this is not my impeachment. It's your client's impeachment.
And it's shocking, yes. No, okay, my last topic then is what I call, what Judge Madlanga and Chief Justice Mogoeng called the magnification of the errors or mistakes made by Advocate Mkhwebane, by judges and other people. Now, you would agree that of all the things that you could be accused of as a public protector, probably the highest would be that you were biased and did not approach an investigation with an open mind, because that's probably the worst thing. Forget about making an error of law or not understanding the law and all that. But if you are biased, that's the ultimate, correct?
I would agree that the highest accusation that could be made is that you clearly favored someone and worked with them to achieve a particular result.
Yes, that's otherwise known as bias, correct?
It's not as simple as that.
Oh. Okay, do you know or don't you know, if you've ever done administrative law, that bias or the nemo iudex principle means not approaching a subject with an open mind and being biased?
Yes. Oh, Sam,
okay.
The highest accusation that can be made against you as a public protector, as a judge, as a lawyer, a young person who wants to be a fit and proper person, is that you lied under oath, or you lied generally. That's why you get struck off the roll if you're dishonest. So that even during the times of Plato, one of the virtues that was regarded as one of the highest virtues in society was honesty, because without honesty, we have nothing.
Correct. Good. And you will
gather going to be our last point.
It is the last point, Chair, but please allow me to develop it.
We were going to be closing now.
And you have been, as we gathered yesterday, Judge Potterell found you to be biased.
She did, and it was not appealed. And for the person who will benefit from that judgment being not appealed to claim a benefit from it doesn't seem right to me. I think John Rawls would disagree with that as just. If you've pursued another person's interest, as I did with Advocate Mshwana, with an eye to justice and to role of the public protector to the ultimate, and then come back and say, I did my best to get to the bottom of this. Then you can come here and say, yes, I put the best of counsel in this case. I did my best to have it appealed, but it came wanting. I even got you involved to explain yourself, and you can't
Yes.
give me any of that.
All right. And the giants that you say you walked on the shoulders of, at least one of them is referred to by Professor Hoekstra as the ANC protector. That would be Advocate Mushwana. And do you know that this is what the SCA, talking about appeals, said about his investigation? An investigation that is conducted in that state of mind might just as well not be conducted at all. The investigator is then no more than a spokesman who adds his or her imprimatur to what has been said, which is all that really occurred in this case. I have said before that an investigation calls for an open and inquiring mind. There is no evidence of that state of mind in this investigation. In other words, he also was accused of bias, apart from just being called the ANC protector. Is that?
May I respond to that?
Yes, of course.
I think it's unfair to malign Advocate Mushwana here without having warned him. The Mail and Guardian case is a case that we use. I've never suggested that the giants on whose shoulders I stand were correct in every way. In fact, the statement said that we look to them to the extent that their way is a better way. But when we found a better way, we do things differently.
Yes.
And if you didn't read my statement and you did not understand the import of my statement, then I'm sorry, sir, because my statement was a 4-page statement, and the last part of it was very clear about not suggesting that my predecessors were correct in every way.
Okay, my last question then is this, that you, well, for the record, both your giants did not obtain clean audit, including you as the giant admirer. But as far as you've also said that you've had accolades from all sorts of bodies. Is it true that one of the accolades that you also received and got was to be named the Person of the Year by the Guptas?
Oh, certainly, but the accolades that I mentioned
just
were
pause,
by my peers.
Just pause, Advocate Madonsela, before you respond. Thank you, Advocate Mpofu. That would have been your last question. Please respond, Advocate Madonsela.
The accolades that I mentioned were the accolades that are relevant to this inquiry. I was asked if I consider myself an expert on, or my strength being the interpretation of the law. I said yes, including the interpretation of the Constitution, and that shone through in the powers of the power protector. I am the inventor of the Equality Code. I have drafted many laws and been part of drafting many laws. I defended the Equality Act in Parliament, and you'll find that in parliamentary records. And I then, in that particular context, mentioned the accolades that have been given by my peers. And it was the Law Society that approved me in terms of my interpretation of the law, the Judge President Lidwaba speaking on behalf of the judges. And then I got the Commonwealth Lawyers Association Truth and Justice Award. I got the Sydney Kenridge Award. I got the Transparency International Integrity Award, the APRM Award, the Association of Certified, the Association of Certified Forensic Investigators Award. And therefore, this was mentioning my peers. Again, I don't like the idea of drenching things into this committee. To you, Chairperson, thank you for the opportunity to assist.
Just pause there. I'm coming back to you. Thank you for responding to that last question. We have now reached the end of our interaction with you as our witness. Before I thank you on behalf of the committee, I want to ask you to say your final remarks and comments to this committee.
Firstly, thank you, Chairperson, honorable members and colleagues, for the privilege to be a witness. I came here as a reluctant witness. I was shocked that for the bulk of the 1st of March, I was the accused person watching on this platform, unable to defend myself. For the bulk of yesterday, I was the accused person. But nonetheless, I do hope that what I have shared with you about what I know about the glorious institution, but not flawless institution that I inherited, I have shared with you today. I also hope that I've assisted you to get a sense of what I did with the 2 reports that you've asked me to be involved in. I was shocked that I was asked if I'm an advocate or not, if I was born here or not. The only thing I wasn't asked is if I'm a woman or a man, and to prove it. My colleagues were made to look like criminals, the ones who are signed. They are respected in their profession. One, a director in a very respected law firm who does these affidavits every day or most of the days of his lives. One, a chartered accountant who does this some of the time. And integrity is important in their professions. And I'm a little bit saddened their names were wrongfully and unnecessarily maligned. But nonetheless, I am an advocate of the Supreme Court of South Africa. It was irrelevant that I was asked, because whoever needed to know that should have just checked the records of the LPC. They would have found my name and my number. But it was irrelevant because the person wanted that information for the purposes of reporting me, and that could have been done after this process. It was not relevant to the evidence that you as a committee need to know in order to make a finding on whether or not the client of Advocate Mpofu, my successor, Advocate Busisiwe Mkhwebane, is guilty of the things she's accused of. And thank you for the privilege. Good luck to everyone who's involved. And thank you for what you're doing to make our country work and work for everyone.